Hi everyone, this is your Professor Tracy Livingston. Welcome to Civil Practice and Procedure. In this course, one of many things you will learn about is the court system. In the court system, as well, the court system along with jurisdictions. So what we will discuss is the federal and state courts, jurisdiction, and venue. I'll start by talking about the federal court system. The federal court system is comprised of a few components. You have the U.S. Tax Court, U.S. District Courts, U.S. Court of International Trade, United States Claims Courts, United States Court of Appeals, United States Court of Appeals for Federal Circuit, and then the top level is the United States Supreme Court. When I say U.S., I don't want to make any assumptions that you all are clear on what is meant by U.S., so that is why I switched from U.S. to the United States, so that you all have a clear understanding. In addition to the federal court system, the state court system is comprised of county court of limited jurisdiction, municipal court, superior court, intermediate appellate court, and the state Supreme Court. Why is it important for you as paralegals to know this information? It's because when you are working in your field, you will have to file different legal documents such as complaints, which is something that you will learn how to prepare in this course. In addition to knowing how to file the complaints, you will have to know which court the complaint should be filed in. And you want to make sure it's filed in the appropriate court. Let's talk a little bit about the path of a litigation case. The first point of reference for the path of a litigation case is to gather facts and investigate the claim. Once you have done that, the next point of reference is to file a complaint and issue what's called a summons. The next step would be to serve the summons and complaint on the defendant. The defendant either responds or doesn't respond. If the defendant does respond, what will happen is the defendant will file what's called an answer to the complaint. The next phase would be the discovery phase, the trial phase, appeal phase, and post-appeal proceedings if it goes that far. In this course, you guys will have an understanding of the alternative options to settling a litigation matter. Most litigation matters typically settle before it actually goes to trial. However, you will learn how to prepare for a trial, pre-trial motions, and post-trial motions in this course. In the meantime, I like to stick with the path of the litigation case, the court system, and then move on from there. So now we have the Court of Appeals. What is it that the Court of Appeals is responsible for? The Court of Appeals is above the trial court, and they usually handle legal appeals involving error from the trial court, also known as the appellate courts. Let's talk a little bit about jurisdiction. Oftentimes in a face-to-face lecture, what I refer to as jurisdiction, I tell my students, one thing, the most important thing to remember, the jurisdiction, when you hear the word jurisdiction, is the authority a court has to hear and decide a case. I often tell students in a face-to-face lecture to not overthink anything. Keep it in simplistic terms. Otherwise, you'll drive yourself crazy because legal jargon can get a little tricky. However, I will do my absolute best throughout this course to break every legal word down for you all, and I totally welcome questions. So let's talk a little further about jurisdiction. So when you think of jurisdiction, actually refer back to what I just said in terms of the authority a court has to hear and decide a case. So typically you want to think of the citizens, it's between the citizens of different states, the citizens of states, and in which citizens of the subjects of a foreign state or has additional parties, the plaintiff and the citizens of the different states of the plaintiff and of the defendant, and as well as where the incident took place. So let's talk a little bit about something that's called diversity jurisdiction. Diversity jurisdiction is centered on citizenship. Parties must reside in different states. The rules are different for individuals and corporations. Complete diversity must exist for federal court to hear the case, not required for class action suits. And then we have jurisdictional amount. When referring to jurisdictional amount, you think of monetary damages. Monetary damages sought must exceed $75,000 for jurisdictional amount to occur. So then you want to talk about subject matter jurisdiction. The authority a court has to hear a particular kind of case, which is what we talked about a short time ago. So you have general jurisdiction, the power to hear any case except those that must be brought in a federal court. Limited jurisdiction, power to hear limited types of cases. So when you're talking about power to hear limited types of cases, you want to think of a divorce matter, you think of a bankruptcy matter. So those particular cases are held in that particular type of court. So let's talk a little bit about venue. Venue, the geographic district where a lawsuit may properly be heard. So you have your federal court venue, your state court venue, and then there is something called change of venue. And when talking about referring to change of venue, in change of venue, which means the attorney has a right to file a motion with the court to change the venue. And that can happen for many different reasons. Basically, if the attorney, he or she feels that the case should not be heard in that particular venue, they can file a motion and the judge can make a decision as to whether or not it should be filed in a particular venue. So that will cover the overall courts and jurisdiction in a civil litigation matter. So I'd like to go back to a little bit and talk a little bit more about the path of a litigation case. In this course, you will learn about how to gather facts and investigate a claim. You will also learn how to file a complaint and a summons, which is what I went over with you guys earlier. Sometimes there is no response. The defendant is required to respond, but the defendant must be properly served. Every defendant has a right to know that he or she is a party to a litigation matter. They have a right to know simply because they need to provide a defense on their behalf in order to pursue the case or to fight the case. Oftentimes, as I said earlier, a litigation case does not always end up in court. Working as a paralegal, you may not always file a complaint, and that's something called pre-litigation. In a pre-litigation phase, it's a possibility that the case can be resolved in the pre-litigation phase, which oftentimes that's what the practicing attorney wants to see happen. In that situation, that's when a pre-litigation case is settled by way of a settlement demand package, and that's in that case, you as a paralegal will have the opportunity to evaluate the client's damages, gather all the client's medical records, medical bills, and put together what's called a demand package. And sometimes you, along with the practicing attorney, will come up with what is believed to be a fair amount to settle the case. Now, some paralegals, some of my students are disappointed if they do not have the opportunity to file a lawsuit. That is the most exciting part, but I'm here to say that the pre-litigation phase can be a little exciting as well. Often advise my students, if you are working as a pre-litigation paralegal, don't be afraid to speak with your practicing attorney about doing some litigation so that you can get the litigation practice. But don't be discouraged, because pre-litigation can be fun as well. Learning how to evaluate the damages for your client and having a good understanding of what is involved in the process of gathering the client's damages and meeting with the client and talking to the client and giving the client updates on his or her matter. It can also be a fun learning experience, exciting work experience while learning as well. So that's what we are covering in the path of a litigation case, pre-litigation, litigation, and post-litigation. And the court system is all involved in the civil litigation course that you guys are taking this semester. I hope you all have learned from my brief lecture in terms of civil litigation, the court system, pre-litigation. I haven't talked much about post-litigation, but that is something that we will have a Canvas conference lecture on, or possibly a Zoom lecture on later in the semester. If you have any questions, feel free to send me an email or schedule virtual office hours. I hope you all have a great day. I will talk to you soon. Bye-bye.